Good evening from Hong Kong, everybody. Welcome to this third session of the HKIAC Chinese Arbitration Insights webinar series. I hope that many of you have enjoyed our first two sessions that were hosted by my colleague, Dr. Ling Yang. She is the Deputy Secretary General of HKIAC and the Chief Representative of our Shanghai office. This series of webinars has been specifically designed to focus on mainland Chinese arbitration issues and how they are relevant to offshore arbitral institutions and users. So in the first session, we discussed foreign related elements and governing law under Chinese laws. And we were joined by two excellent guest speakers, Helen Shu from Bangda Partners and Mei Tai from Herbert Smith Freehills in Hong Kong. Then in the second session, we focused on the seat of arbitration and foreign arbitral institutions administering arbitrations in mainland China. And we were joined in that session by Jingzhao Tao of Arbitration Chambers Hong Kong and by Junfei Ng, QC of 7 Bedford Row. If you missed those sessions, they are available on our website under our audio-visual library, where you will be able to find all of our webinars, lectures and interviews, and you can watch them for free at any time. We are really pleased with the interest that's been shown in this series. So to date, we have had 2,580 viewers from 90 jurisdictions of the series. So today's topic is mainland China and investment arbitration, which of course is a very interesting topic from multiple different angles. The field of investment arbitration itself is of course a very dynamic one. As of last year, we know that there are just under 3,000 concluded bilateral investment treaties and a further 390 treaties with investment provisions. We have a corpus of investment arbitration law comprised of about 500 decisions and concluded cases, which split roughly half in favor of a state and half in favor of an investor. And we are also in the midst of a massive reform exercise in the context of the UNCITRAL Working Group 3. Now, China is one of the most prolific signatories of bilateral investment treaties. Just coming second to Germany. The first bilateral investment treaty that China signed was back in 1982 with Sweden, and since then it has signed a total of 138 bilateral investment treaties. It also has a trilateral investment treaty with Japan and South Korea, and also has concluded 13 other free trade agreements with investment provisions. And the content of those treaties is diverse, both in terms of substantive protections, but also in terms of access to international dispute resolution. So in today's webinar, we're going to look at some of the content of the treaties and how China's treaty-making policy has evolved over the years. Now, notwithstanding the fact that there are many Chinese investment treaties, and China ratified the ICSID Convention almost 30 years ago, back in 1993, it's somewhat surprising that to date we only have a handful of cases involving Chinese parties, whether as a Chinese investor claimant or the Chinese state as a respondent. And this is also notwithstanding the fact that China is now the world's largest capital exporting country and has been a net capital exporter for some years now, not many, many years, but at least 5. And we also, of course, immediately think about the Belt and Road Initiative. But in addition to being a capital exporter, China is also the second largest capital importer in the world, second to the US. So we'll also look today at the outcomes of some of those arbitrations, as well as some of the issues that come up in a recurring fashion across Chinese treaties. Now, one thing that is clear is that China is becoming increasingly engaged in investor-state dispute settlement, and that is perhaps rightly so, given the sheer number of treaties and the volume of investment activity. But China's delegation to the UNCITRAL Working Group 3 is active and is playing an important role in engaging in investor-state reform. And we will discuss today also some of the key areas of reform going on within the context of UNCITRAL and China's position in respect of them. And then a further area we will take a look at is China's signing and successful negotiation of two very important instruments. First of all, the Regional Comprehensive Economic Partnership Agreement, which is between the 10 ASEAN countries and 5 other economies, including China, as well as the EU-China Comprehensive Agreement on Investment, which in its ultimate form is intended to replace the various bilateral investment treaties that China has with the EU member states. And so we'll also discuss in this webinar those instruments and their approach to investor-state dispute settlement. And then today we'll conclude the webinar by looking at the role of commercial arbitral institutions like HKIAC and like some of the major commercial, major arbitration commissions on the mainland in respect of investment treaty arbitration, and what some of the different institutions offer in terms of services specific to this field. Today, we are very fortunate to be joined by 2 prominent experts in investment treaty arbitration and also experts in China-related dispute resolution. We have with us today Chao Li Jun, who is a partner at Zhonglong Law Firm in Beijing. He is internationally recognized as a leading lawyer in China-related dispute resolution and in international arbitration generally. And I note that for 2 years in a row, he was voted Lawyer of the Year for Dispute Resolution by China Law and Practice. We also have with us today Emmanuel Giacomi, who is a partner at Sherman & Sterling based in Beijing and in Shanghai, and in Singapore. He has extensive experience advising both companies, state-owned enterprises, and governments in international commercial and treaty arbitration. He is an adjunct professor in Beijing, and he is widely recognized as one of the most skilled arbitration specialists of his generation. So Li Jun and Emmanuel, thank you very much for being with us today. We're really looking forward to our discussion with you. So we will now have a panel discussion about the topics that I just introduced. If you have questions, please use the Q&A function on Zoom, and we will have some time at the end of the webinar to address some of your questions. Okay, so to get us started in our discussions, can I turn to you, Emmanuel, and ask you, can you introduce to us China's policy towards investment arbitration and how that policy may have evolved over the years?
Yeah. Thank you, Sarah. And first of all, thank you very much for inviting me to this webinar. I've found the 2 first episode of the webinar very interesting, and I'm really, really proud to be part of the 3rd one. So on China's investment policy, I think the first thing to say, and you said it in the introduction, is that China is one of the countries in the world that has been the most active in terms of treaty making with respect to investment arbitration. It has signed a staggering number of 145 BITs, 19 treaties with investment provisions. But as you said, all of these treaties are not created equal. And what's interesting is that the evolution of the content of these treaties actually reflect the evolution of the Chinese economy from a capital importing country in the 80s and 90s to a largely capital exporting countries from the years 2000 onwards. So broadly speaking, you can categorize these treaties in 4 main categories, and you see them on the next slide. So you have 4 generations of treaty. The first generation and the second generation, which you see in blue on the slide, were concluded in the 80s and 90s when China was predominantly importing capital. And as you would expect, these treaties offer little protections to investors. And you see that in particular in the dispute resolution clause, because these treaties either did not offer access to arbitration to investors or very limited access to arbitration. And you have an example of that in the next slide, which is the treaty between China and Ghana, 1989. That's the dispute resolution clause. And you see that investors are allowed to submit to arbitration only claims concerning the amount of compensation for expropriation. So that's a very, very narrow category of disputes. So protection for investors, very limited. But then, of course, and I think on the next slide, you have another example of this, that's second generation, basically the same China-Israel BIT this time, 1995, again, disputes to be submitted to arbitration limited to the amount of compensation in case of expropriation. Now, if you compare that with the treaties of the third generation, which you can see again on the map, and this time you can see them in green, these treaties were concluded in the years 2000 and onwards, when China started to massively export abroad and invest abroad. And as you could expect, these treaties are indeed more favorable to investor. And to take only the example of the dispute resolution clause again, which you can see on the next slide, here you have the China-Germany BIT 2003. So as you can see, only 2 pages, very short arbitration clause, but that arbitration clause provides that any dispute concerning investment this time can be submitted by the investor to arbitration. So of course, that's way more favorable to investor. Now, what about today and the most recent treaty signed by China? You would expect that with the Belt and Road Initiative, with the massive investment that China is making abroad, the recent treaty signed by China would be even more favorable to their investors. But surprisingly, or not surprisingly, we'll discuss that later, I think, it's not really the case. And if you look at the fourth generation of treaty, which again, you can see on the map, this time that's, let's say, in peach on that map. So these treaties were signed in recent years, and to take only, again, the arbitration clause as an example, you see on the next slide, it's the China-Canada BIT that was signed in 2012. You see that the arbitration clause is way more detailed than what we saw in the third generation treaty, 10 pages, with a view really of limiting and controlling access to arbitration for investors. So that's a generation of treaty that really is way more balanced in favor of the interest of the state, maybe possibly in reaction on some cases that were brought against China in the recent years.
Thanks, Emmanuel. And I think that brings us nicely to the next topic that I want to discuss with Li Jun is, you know, we mentioned that there are a few cases in which China has been involved both as a respondent state, but also Chinese investors going abroad, but not that many. But what can you tell us, Li Jun, from that handful of cases? What are we seeing in terms of outcomes and in terms of recurring issues that are coming up on these because of these Chinese treaties?
Thank you, Sarah. Let me start by saying that it's my pleasure to join you and Emmanuel for this webinar. Thanks for the invitation. You have heard from Emmanuel about the 4 generations of the China BITs. Sarah mentioned that there are only a handful of cases. So I did some search before this webinar. Altogether, there are 20 cases involving China up to date. Among the 26 involve either Hong Kong or Macau administrative regions. So if we are talking about mainland Chinese involvement in investment arbitration, basically there are 14 cases. And the 14 cases can be divided into two groups with even number, 7 for cases initiated by Chinese investor, and 7 for cases in which the Chinese government is the respondent state. Among the 7 cases initiated by the Chinese mainland Chinese investor, 4 were exit cases and 3 were non-exit cases, as you can see from the charts here. For the 7 cases against the Chinese governments, 5 are exit cases and 2 were non-exit cases. So altogether 9 cases administered by exit as opposed to 5 non-exit cases. These figures show that Chinese parties are more familiar with exit, although there are still a significant number or percentage ad hoc arbitrations, which is probably, in my view, because they were filed under old first or second generation BITs, which were basically concluded at a time before China acceded to the ICSID Convention in 1993. So there's no provision in those earlier BITs on ICSID arbitration. Well, the 14 cases, although the overall number is not quite big, but there is a sign that the growth has been accelerated. Among the 14, 6 were filed since 2020. Including 3 in which the Chinese investor brought up the arbitration against a foreign host state, and 3 cases brought up by foreign investor against Chinese government. Speaking of the outcome of those cases, among the 7 cases initiated by mainland Chinese investor, 2 were denied jurisdiction. We are talking about Ping An versus Belgium and Heilongjiang versus Mongolia. 1 case was settled. That was the Beijing Urban Construction, or BUC, versus Yemen. Beijing Urban Construction succeeded in the jurisdictional stage, and then the case was settled. 1 case was withdrawn. That is Jetson versus Grace. It's in relation to the solar industry. So the case was withdrawn after Great Government announced the old law and announced new law and repealed the old law. So 3 other cases which were filed in 2020, they are still pending. Among the 7 cases in which the Chinese government was the respondent state, 1 case was settled as early stage. That's the Akron-Berhad case. 1 case, the tribunal granted early dismissal. That's Ansan versus China, which is my case. I was one of the legal counsel in that case. The other 5 are still pending. So these are the figures for Chinese involvement in the investment arbitration. Sarah?
Thank you very much, Li Jun. And so to date, there is no case in which the Chinese state did not prevail. It was either settled or the successful result in the Ansan case for the Chinese state, and then the rest are pending. So we'll wait to see what happens. And I know that in some of those cases, we had situations where there were, let's say, inconsistent decisions with respect to the interpretation of the clause. Investor state dispute settlement is available for determining the award of compensation following an expropriation. And so I think there we see some inconsistency between different tribunals' approaches to the same wording, and perhaps a lack of predictability and making it therefore difficult for legal advisors to advise their clients. But when we look at the anti-trial working group reforms, one of the central concerns for the reformers with respect to inconsistent decisions and trying to find a way, either structurally or some other way, to deal with that. So can we now talk about the reform process at ANSI-TRAL? And Emmanuel, if I come to you, could you give us an overview of some of the reform areas that ANSI-TRAL is looking at, and discuss some of the new mechanisms that are being contemplated and perhaps the positions of the EU and the USA?
Yeah, sure. So if we're talking about recent trends in ISDS, I would say that those trends are not really favorable to ISDS, and it's indeed pretty much the opposite. And I have the memory of a seminar with government officials in which we participated together, where most of the government officials around the table were actually against the current system of ISDS. And the irony of this is that in the past, when most of the respondent states were from developing countries, nobody had any problem with that system of ISDS. But is when developed countries started to become respondent state being sued and losing that all of a sudden that system became the worst system in the world, untransparent, undemocratic and whatnot. And I would say that most of the criticism against the system, frankly, comes from a misunderstanding of the way it actually works. But the criticism is here. It's here to stay. And as you said, so much so that the UNCITRAL has set up a working group to discuss proposal for reform of ISDS. And here on that slide, you see the main areas of reform that the UNCITRAL working group is contemplating. Number one, whether to replace ad hoc tribunals set up to hear each and every single dispute as we know them today by a standing multilateral, one or several standing multilateral mechanism. Number two, how to improve arbitrators' appointment methods and ethics. Number three, how to encourage state parties' involvement and control mechanism on treaty interpretation. And number 4, 5, and 6, how to develop dispute avoidance, reduce cost, and address third-party funding. Now, what's interesting is that in the context of that working group, all members of the UNCITRAL have had the possibility to submit public comments. And the EU has done so, China has done so, and the US has not done so at the beginning, but is participating in the working group. And what we can say about those discussions is that as far as the EU is concerned, the EU is certainly the most critical of the system. In particular, the EU has proposed that the ISDS system be replaced by a permanent investment court system, or ICS, with permanent judges, with an appeal mechanism. But even that proposal is still heavily criticized in Europe, with many people thinking that the system should be altogether abolished. And you may know that last year, the EU has forced most of the member states to terminate their intra-EU BITs. So that's a criticism that exists a lot in Europe. And you can see that on the cartoon on the next slide. That's a cartoon that was published by a German NGO on ISDS. And you see here ISDS is represented as a wolf that Grandma Europe is trying to dress up into a new investment court system, but espace niched, it doesn't fit. And it's likely that the wolf will have Grandma Europe for dinner. So that's a bit extreme, but it somehow reflects really the trend towards investment arbitration, essentially in Europe. Now, the US, on the other hand, have been less critical of the system, but given some of the declarations that Biden made in the past, this also doesn't look that promising. You have an example here in 2020, May 2020. I don't believe that corporations should get special tribunals that are not available to other organizations. I oppose the ability of private corporations to attack labor, health, and environmental policies through ISDS. And I oppose the inclusion of such provisions in a future trade agreement. So that's pretty much the trend in Europe and the US at the moment. And what's interesting is that China's position on this topic is slightly different.
Speaking of which, Liu Jun, could you take us through China's position in respect of the major areas of reform in the UNCITRAL working group?
Well, let me start by saying, the Chinese national leaders, they are supportive of China's continued involvement in ISDS, and they are saying things like, this ISDS system is helpful for promoting investment and trade. It's good for beneficial for the entire world, the economy of the whole world, things like that. China, the efforts to the UNCITRAL Working Group 3 is led by the Ministry of MOFCOM. And the MOFCOM, if I remember correctly, they submitted a position paper setting out the Chinese government's position on ISDS reform to the Working Group 3 in July 2019, and set out all the concerns it has to date. And among these concerns, you will find many familiar things. data shared by other countries, including, the lack of error correction mechanism, the methods for appointment of arbitrators and the impartiality of arbitrators, the lack of predictability of the decision by the various arbitral tribunals, the lack of transparency with third-party funding, and the excessive cost time spent on ISDS procedures, etc., etc. In relation to the concerns, China offered several suggestions in the position paper. Among others, China calls for establishment of a permanent appellate mechanism. This is different from the EU's position, because the EU is calling for a two-tier system, which are all permanent. For China, it's only calling for a standing or permanent appellate system. For the first trial, they still prefer to have a ordinary arbitral procedure. In the position paper, China expressly says that the choice of arbitrator has been recognized for a long time as one of the most attractive and most helpful mechanism for any international arbitration. So it should be careful for the various countries to think twice before abolishing the system. China also says that there shall be a stricter code of conduct for arbitrators, so as to avoid things like double hatting, professionals sitting as counsel in some cases and as arbitrator in other cases. So switching roles and their positions could be compromised, things like that. There are other suggestions, but I think we don't have to go into details to save some time. What I mentioned are the major concerns from China.
Thanks, Li Jun. And then now I want to talk a little bit about China's involvement in two of the major instruments I mentioned earlier, the RCEP and the China-EU Comprehensive Agreement on Investment, because I think it's interesting to think about, first of all, China's position in the working group context, but then also see what they're doing in terms of what China is agreeing to in their treaties, and their newer treaties and these newer instruments. So perhaps Li Jun, could you take us through the RCEP, which is now the biggest free trade pact that exists in ASEAN, and then take us through the China-EU Comprehensive Agreement on Investment, and focus on or take us through the approach of these two instruments to investor-state dispute settlement.
Sure. May we move on to the next? Yes. Well, I have prepared this slide to show the map of the RCEP signatories. RCEP was basically, concluded between the 10 ASEAN countries and 5 other countries, including Australia, New Zealand, China, Japan, and Korea. It was concluded last year, and according to the projection, the effective date shall be January the 1st, 2022. One notable feature is that in the RCEP, there is currently no provision on the ISDS mechanism. However, according to Article 10.18.1, the parties are committed to enter into discussions no later than 2 years after the effective date, and the discussions shall be concluded within the 3 years, the next 3 years. That means to say, calculating from January 2022, so if everything goes okay, the section on ISDS mechanism will be added to the RCEP agreement by January 2027. So what are the current position? For now, there is no ISDS provision, so the dispute between those member states can still be resolved according to the current regime. BIT, MIT, or the China are seeing they have a investment agreement, etc. China, Australia has a FTA, etc. So interesting issue would be, there is state-to-state dispute settlement provision in the RCEP agreement, which will refer to the disputes between the state-to-state to resolution by a so-called panel, and the panel will render its decision in the form of a final report. This is in Article 19.15. So there are lots of similarities between the panel system of RCEP agreement and the WTO system. However, unlike the WTO, the reports rendered by the panel are final in the sense that there is no further appeal against the report by the panel. So interesting question here is whether the investor state dispute can be resolved through state-to-state dispute settlement system. In general, the host state will offer diplomatic protection. I mean, home state will offer diplomatic protection for the investor from its own country. However, in practice, this can very rarely escalate into a dispute between host state and home state. I think in the old time, even for the very old BITs, there are provisions for resolving state-to-state disputes. So we didn't see many in practice. So I would only say, well, maybe in principle it's a yes. So the investor state dispute can be resolved through the state-to-state mechanism, but in reality, maybe no. So moving on to the next slide, please. This is about the China-EU CAI. We all know there has been long time negotiations between EU and China, and the negotiations were finally concluded in December last year. However, for political reasons, the EU Parliament has frozen the ratification of the CAI agreement in May 2021. Like the RCEP agreement, there is also no ISDS provisions in the current version of the CAI that has been released. According to one provision, that's Section 6, subsection 2, Article 3 of the CAI draft, the negotiations will be completed within 2 years upon signature by both parties. And in the 2 years' time, the parties will consider the work of the Ancestral Working Group 3 on ISDS reform. So we don't know how long it's going to take for the EU Parliament to acknowledge its freezing decision. But if everything goes well, then it's going to take another year for the ISDS section to be added to the CAI agreement after it was signed by both China and the EU side. Likewise, there's also state-to-state dispute settlement provision in the CAI draft, and any dispute between state-to-state are to be referred to arbitration panel, which will render a final report. And similarly, the final report will not be subject to further appeal. This is also different from the WTO system. So you will see a lot of similarities between RCEP and CAI. On the one hand, this represents the recent trend in those kind of agreements. On the other hand, this also shows China's attitude as reflected in the two agreements to which it is potentially a party.
Thank you, Li Jun. Thank you for that comprehensive overview of those two really important instruments. Can I turn back to you, Emmanuel, and could you take us through some other agreements signed by China, free trade agreements or other BITs, which may contrast somewhat to the position China has taken both in these instruments and in other contexts?
Sure, Sarah. I think it's actually interesting to compare the RCEP and the CAI with indeed other recent agreements signed by China. One of them is the China-Australia Free Trade Agreement, 2015. It does contain, unlike the RCEP and the CAI, dispute provision for investor-state dispute settlement. But as you see on that slide, these provisions are much less favorable to investors than what we saw in the third generation treaty. And in particular, you'll see that on the slide is the first bullet point. The protection, substantive protection given to investor is limited in that treaty to national treatment and MFN. It does not include, for example, protection against unlawful expropriation, which you will find typically in most treaties of the third generation. And in relation to arbitration, investors have the possibility to go for arbitration, but here again, the dispute resolution clause is very narrow, and you can see it on the next slide. It's Article 9.12 of the treaty, and you will see here that investors can only submit to arbitration claims that the respondent, so the state, has breached an obligation in Article 9.3 of the treaty, and 9.3 is national treatment. So nothing else than national treatment. So of course, this is very narrow. So does that mean that this is China's current position on investment arbitration? Does that mean that China has somehow abandoned the protection of its investor when they invest abroad? Not necessarily, because as you know, Australia has taken in recent years a very strong stance against arbitration. And given the bargaining power between both parties, this FTA is likely to represent a form of compromise, I would say, between Australia's position and maybe China's position. So what's maybe more interesting is to look at another FTA concluded by China recently, 2019, and that one is with Mauritius. And again, given the bargaining power between the parties, this agreement is more likely to represent what actually China's position on investment arbitration is today. And if you look at that treaty, you'll see that this is way more favorable to investor. You will find, that's the first bullet point, all of the traditional substantive protections that you would find in treaties of the third generation. And in terms of arbitration clause, just like the China-Canada BIT we saw earlier, the clause is very detailed, it's very long, 10 pages again, but it allows investors to file pretty much all type of breaches of the treaty to arbitration. And you see it on the next slide. It's Article 8.24 this time, and you see in blue that the investor has the possibility to file claims for breach of all of the substantive protection to arbitration. So as you can see, this treaty is way more favorable to investors, which makes sense given the Belt and Road Initiative of China today. At the same time, it's also more balanced than the third generation treaty in favor of the interest of the state, which also makes sense given the recent cases that have been brought against China. I would add maybe a last point on this thing. On RCEP and CAI, it's true that these two treaties do not contain dispute settlement provision, but that shouldn't be too much of a concern for investors because China has signed other treaties with most countries in Asia and also with most European countries. And these treaties, for example, the China-ASEAN Treaty or the China-Japan-Korea Treaty are very protective of investors. So of course, it's interesting to see what China and its partners will do in the RCEP and CAI. But in the meantime, investors can perfectly rely on these other treaties in parallel.
That's right. And given the number of treaties that China has signed, it is the case, and the number that are in force, over 120, it is the case that there are situations where you would have overlapping protections and jurisdiction under different treaties. So there is some choice, but then you may run into some issues around temporal jurisdiction and so forth, and the different scopes within the different treaties. So yeah, Okay, thank you very much for that. That's really interesting to see the different approaches taken by China in the different treaties and how it appears that it is somewhat or even very much impacted by the contracting partner. So a wide, as we said at the beginning, the content of the treaties is diverse. So thank you very much. I think now we'll turn to our final topic before we open up to the questions and answers. So that is with respect to the role of international commercial arbitration institutions in investment arbitration. And we'll take a look at some of the offerings and what we think might be the most meaningful. But first, to introduce this topic, Emmanuel, can I stay with you to take us through how treaties function in terms of how decisions are made around which institution is going to administer a case and which procedural rules will be applicable?
Yes, so there's a misconception, I don't know, but a lot of people really associate investment arbitration to ICSID. And that's a misconception. It's true that in a number of investment treaties, the only choice that is given to investors if they want to go to arbitration is to go for ICSID arbitration. But it's not always the case. And investors don't have to go to ICSID in all cases. There are exceptions. Number one, not all investment arbitrations are based on investment treaties. Sometimes they are based on a contract between the investor and the state. And of course, in their contract, the parties are free to choose any arbitration institution they want to use if one day there is a dispute in relation to their investment. And number two, in many treaties, treaties will actually give an option to the investor to go either for ICSID or to different types of arbitration. And here, I'm using again the example of the China-Mauritius FTA. You'll see same provision we've looked at earlier. It's Article 824. So this article gives the investor an option to go to ICSID, either under the ICSID Convention or the ICSID additional facility rules, but the investor can also choose unsitual arbitration, and if both parties agree, can also choose any other arbitral institution. So unsitual arbitration is ad hoc arbitration, of course, but when I represent claimants in investment arbitration, I would typically propose that the parties agree to use an institution to administer the case. And a number of arbitral institutions are perfectly able to do that, the HKIAC, the PCA being some of them. And very often the respondent state agrees because it's indeed much easier to handle an arbitration when you have an institution administering the case. Now, of course, the choice of that institution is crucial when you decide to do so. And in particular, it's because the arbitral institution will be in charge of appointing arbitrators if there is difficulties in the appointment process. And so, of course, you want to choose an arbitral institution that has a very strong track record in handling big arbitrations, very strong track records in appointing arbitrators, and preferably also an arbitration that has experience dealing with state parties, preferably in investment arbitration as well. Now, there are some arbitral institutions that have issued specific rules specifically targeted for investment arbitration. It's probably a plus when you want to convince the respondent state that it should choose that institution. But as far as I'm concerned, I don't believe it's a must.
Thanks, Emmanuel. And speaking of some of the institutions that have promulgated investment arbitration rules specifically, that's true of some of the major arbitral commissions on the mainland, isn't it, Li Jun? Could you talk to us about some of those institutions and what they've offered?
Well, let me first echo what Emmanuel just said. You know, people in China, when they talk about the investment arbitration, most of them will equal investment arbitration to ICSID arbitration. And now having realized that for investment arbitration in the BITs or other IIAs, international investment agreements, there are usually multiple choices. Then if they find that there is one of the choices is ICSID arbitration, they still probably go to ICSID. This has to do with the cultural background of Chinese parties because they tend to go to the most established institution or bureaucracy for litigating or resolving their disputes. But having said that, I think people now are more open-minded to various choices. One of the choices being ad hoc arbitration. We are talking about amending the PRC arbitration law to allow ad hoc arbitration for resolving, of course, mainly the commercial disputes. But then, Sarah, you mentioned that the mainland Chinese institutions they are now offering investment arbitration services. This at the beginning comes as a surprise for many users, honestly. But I was not surprised because the institutions, their mindset is that they are open to all the users' willingness. Whenever users want to choose them for doing any kind of dispute resolution work, they are open-minded to that. So the institutions such as CTEC, Beijing Arbitration Commission, and the Shenzhen Court of Arbitration, they all promulgated their rules of investment arbitration in recent years to offer such services. I should say, there is a perception that because mainland China will be the major player for investment arbitration, either as an investor claimant or as respondent state. So the perception is that mainland China wouldn't be deemed as a neutral seat for resolving disputes, ISDS disputes involving Chinese parties. So most likely it would be difficult for those three institutions to attract parties to file arbitration case through these institutions, or simply put their names in the international investment agreements. But having said that, I think it's a matter of bargaining power. Like Emmanuel said, if a investor has a bargaining power, it may, in the contracts that is signed with the state entities, provide that the dispute, which are in nature investment or investor state dispute, should be resolved through one of the three mainland Chinese institutions that offer such service. The other thing I wanted to say, in light of the perception that mainland China wouldn't be deemed as a neutral seat, I think Hong Kong IAC does have the good reputation of being neutral and could be an excellent forum for resolving China-related ISDS disputes. Of course, Sarah, you are the expert. You are best positioned to see that.
Yeah, we have, HKIAC has administered investor-state arbitrations, treaty-based investor-state arbitrations. Those were under the UNCITRAL rules. No surprise there, because most investor-state cases are either ICSID or UNCITRAL rules. And we revised our main set of rules, our administered arbitration rules, back in 2018. And when we did that, we did consider the option of promulgating a special set of rules for investor-state arbitration, but we concluded that the administered arbitration rules were fit for purpose, also for investor-state cases, and also given our long track record of running UNCITRAL cases since the 1980s, then we had the requisite experience under that set of rules. And as Emmanuel pointed out earlier, I think it is very important that if you are if you have the option of choosing an institution, you really do need to opt for an institution that has investor-state expertise, because if you are putting together a list procedure for the appointment of a presiding arbitrator in investor-state arbitration, that is a very important function, and that is a very, you really want to have an institution that knows what it's doing in that circumstance. On the next slide, I've listed out some of the features that we think are important in investor-state arbitration. So UNCITRAL rules experience, definitely. Also, one of the initiatives we put forward in 2016 was to offer free hearing space for cases involving states on the OECD's DAC list. So that's the list by which certain states are eligible for financial support. And so we have had a case in which we had a state on the DAC list. It wasn't an investor state case, but it was the underlying contract claim related to an ICSID case. and there the parties were eligible to have our facilities here in Hong Kong or in Shanghai free of charge for the lifetime of the case. And I think, for some states that's going to make a difference. For others, it's a drop in the bucket, but I think it's important for some states to be very conscious of cost savings. And then in terms, I think, of your staff, you really do need to have staff who have expertise in investor-state arbitration, and we certainly have that. Former PCA employees, former ICSID staff, and former employees of law firms with investment treaty practices, and also on our governing body and amongst our decision-making committees, we have a lot of expertise in investment treaty arbitration. We also have a tribunal secretary service, which is very common investment treaty arbitration. And one thing that's really interesting between the governments of mainland China and Hong Kong is that there is a closer economic partnership agreement. And within that agreement is an investment dispute resolution mechanism, which never goes to arbitration, but does go to mediation. And within that context, we are one of the administering institutions. That has not yet been used, but a very interesting use of mediation that I think a lot of states are interested when it comes to investor-state arbitration. But like I said, we've had 2 investor-state cases on our docket, one of which has concluded and one of which is ongoing. We have some time now for questions, and one of the questions that is coming up repeatedly is whether or not you have any predictions with respect to the EU-China CAI agreement. What do you think is the future of that agreement? When do you think the freeze on the CAI will be lifted, given the current political climate? Li Jun, do you have any comments or insights or predictions to make in that regard?
Well, I think that from at least the Chinese side will be eager for this CAI, which has been negotiated for a long time and so difficult to achieve. Chinese side will be eager to see the EU Parliament, adopt a more flexible approach, or just stop its previous orders from being implemented. I have no idea about the how the procedure in the EU Parliament works, but at least the Chinese side will be eager for this CAI to be taking effect as early as possible. So I'm sure there will be discussions among the politicians from both sides. So political reasons, we don't know how long this is gonna take. Maybe a few months, maybe 1 or 2 years. I don't think it will be forever. So this question is probably from a European viewer who is from where? Poland, our friend. You are in a better position to make a judgment on that.
Yeah. Do you have anything to add, Emmanuel?
Maybe a few words on the content and what we can expect to see in this agreement. The EU has been pushing really, really hard for this idea of an investment court system, both in the anti-fraud group and in general. So you can expect that this is going to be a very strong point in the negotiation, and that the EU will likely not give any ground on this very easily. So the question is whether the Chinese will accept this or not. From the China-Australia agreement, it seems to show that China is open to a certain amount of flexibility in finding compromises with their partners. So my expectation is indeed that in that respect, it's very probable that you'll see a form of investment court system, maybe with some adaptations, but you'll probably see that in the CAI.
Right.
Well, maybe I can echo on what Emmanuel just said. I agree. This will be the major area for the 2 parties to discuss going forward when trying to settle down on the disagreements on the ISDS system. China is open-minded to a permanent appellate system. That's already stated in the petition paper and also reflected in the China-Australia FTA. But for Chinese officials to give up the choice of arbitrators, I think that will be something difficult. But I agree with Emmanuel that they are flexible. There may be ways for resolving this disagreement. I can see that EU and Vietnam, in their FTA, there's an agreement on the appellate system. But for Vietnam, it will be, in my view, a disadvantage because when they are appointing standing members to the court or appellate body, whatever it is called, the individuals from the Vietnam side wouldn't be as experienced as those European professionals. So that is also something to be considered by the Chinese side.
Yeah. Moving on to another question we have here with respect to the Belt and Road Initiative. And I think, what we were talking about in terms of how China is going to approach its new treaties and its new negotiations, it's going to become so much more important going forward, just given the fact that we know there will be more disputes and a lot of Chinese investors will be along the Belt and Road are going to be caught by first or second generation treaties, which are much more restrictive. The question here is, could you please address the issue of resolving investment disputes in the context of the Belt and Road Initiative? What would be possible arbitral institutions for resolving these disputes, and what are some of the challenges?
Maybe I can say a few words. Indeed, there are challenges, and you've just mentioned, Sarah, that one of the main challenges is that a lot of countries that are included as part of the Belt and Road Initiative actually only have first and second generation treaties with China, either first or second generation or no treaty at all. So when Chinese investors go and invest in these countries, the question is, what do you do if you want to start an investment arbitration against the state? One of the best ways to do that is what we call investment structuring, which might or might not be possible depending on the treaties, and it consists in, for the investors to use a third country to then invest in the target country so as to be able to benefit from the protection of the treaties between the target country and the third country. That's possible under certain circumstances. Under other circumstances, tribunals have considered that it was not possible. But that's something that investors definitely, when they invest in those type of countries, should consider. Another possibility when they have not done that at the very outset of the investment is to consider using the most favored nation clause that you find in some treaties. And here again, as you've said, decisions are contradictory, not only on the extent of the arbitration clause, but also on whether you can use the MFN clause to extend your dispute resolution clause and borrow a dispute resolution clause from another treaty. So there are a number of challenges. In terms of arbitral institution, well, very often it's fixed by the treaty, right? So it's very often either ICSID. Sometimes you see very often in Chinese treaty SCC, the Stockholm chamber, and then indeed arbitration rule, which allows you to choose another arbitration. Question is whether in future treaties signed by China will want to include Chinese institution or specific arbitral institution that have been specifically created for the Belt and Road Initiative. And this really depends on what China will do in the next generation of treaties. But so far, we haven't seen any reference to those institutions in the recent treaties.
Yeah. Well, Li Jun?
Yes. Well, I just want to highlight, as Sarah and Emmanuel both mentioned, there are contradictory decisions. There's I should say two well-known cases on the jurisdictional challenges based on the provision on arbitration in the first or second generation BITs, because those provisions only calls for arbitration of disputes in relation to the amount of compensation for expropriation. So one of those cases is the Beijing urban construction versus Yemen. The other case is Heilongjiang versus Mongolia. And Yemen and Mongolia happen to be on the Belt and Road, along the Belt and Road. So the two tribunals render two different, which are contradictory decisions on the jurisdictional challenges, because the first tribunal, well, let me say this, the challenge is about whether the arbitral tribunal can hear dispute beyond the compensation amount. So in the first case, the BUC versus Yemen, the tribunal said yes, because there is a fork in the road provision. On the second case, the Heilongjiang versus Mongolia case, the tribunal said no. They gave very narrow interpretation about the wording of that provision, saying only the amount of compensation can be arbitrable. And the other things, whether the expropriation happens, whether expropriation is lawful, those are not within the scope of arbitration and not arbitrable. On that basis, it denied its jurisdiction. So similar situation, similar provisions, but different decisions. So that can explain or add a footnote to the complexity of resolving ISDS disputes along the Belt and Road. Yeah. And Emmanuel just mentioned two ways, but in my opinion, these are very good suggestions, but neither of them will be very helpful if you still have the current old generation BITs, which means to say in the long term, there shall be negotiations for new BITs to replace existing ones, so that in the future the investors along the Belt and Road will have a less complex problems like this.
Yeah, I think you've hit the nail on the head, Lee Jun, and that there's a lot of unpredictability around that issue for future disputes, and it's going to come up again and again.
Yes.
We have reached time, and I just want to thank you so much for all of your work and your participation today. It's been fabulous. And thank you to everyone who's joined this webinar. We could go on for much longer, but we won't. And just to raise to your attention that the next and the final session in this series will be on the 23rd of July. It's on obtaining interim measures and enforcement of awards in mainland China. So please do join us for that. Thank you very much.
Thank you, Sarah.
Thank you, Sarah.